Hi guys, Clint Kuhns here with Anderson Business Advisors, and in this video we're going to talk about some of the stupid mistakes people make when it comes to creating their LLC operating agreements. All right, let's get started. Okay, so I'm going to talk about some mistakes that I see oftentimes when I review existing operating agreements that people have set up with either inexperienced attorneys that are not familiar with creating operating agreements for real estate investors, or worse yet, you went on the internet, right? You went to Zoom.com and said, give me an operating agreement, and you think you're protected. This happens all the time. People have these operating agreements that they're owning real estate under, they're operating their business under, and they don't know what's in there, or more importantly, they don't know what's missing. And as a result of it, this will come up when you're involved in a lawsuit, and it could come back to bite you. Well, I want to give you 8 issues that I see many times in operating agreements that you should look to avoid in putting together your LLC operating agreement. Okay, so what is the first one? The first issue I have is going to be member managed, all right? We don't want to do member managed. If you're not familiar with this, when you set up an LLC, you have different styles of running that company. It can be either manager managed or member managed. Now, the reason I don't want to do member managed is because in a member managed context, all of the members can exercise control. So if you want to do something in the future, like gift away part of it to your children, and then you want to sell the property, guess whose permission you have to get? Your kids. You want to refi the property. You got to get your kids' permission to do it. Keep that out of there. So the other problem with member managed is when you file it with the Secretary of State, many times the Secretary of State would like to know who are the members. If you set up a member-managed LLC, then they want you to list the members. So now you disclose the fact to the world at large that you own this LLC. Not a lot of privacy there. The other side of the coin is what is referred to as a manager-managed LLC. And even though you're going to be the member and the manager, still I like to set them up as manager-managed because it tells everyone, hey, this is a person that has control. They run the company. If you give ownership away later on to your children or someone else, you're still in control and you never lose that control. So I would avoid member managed and opt to go always with manager managed limited liability companies, unless you're using one of my strategies where we're looking for anonymity. Then forget what I just said. But when you're setting up an LLC and you're not doing the anonymity side, and you can look at my other videos on that with Wyoming limited liability companies and setting it up, that's going to be a little different in that context. Okay, number 2. This is a bad one. Number 2 is going to be forced distributions. Okay, so what does that mean? So in a limited liability company, you have the ability, right, to distribute money out to yourself. That's called a distribution. So you have your LLC. Let's see, here's my LLC right here. It's got some money inside of there. I'm a member and I take money out. Okay, when I take money out as a member, that's called a distribution. Now, the problem I run into you see on operating agreements is they have provisions in there that require the company to distribute the profits on an annual basis to its members or distribute enough money to its members to cover their tax liability. Now, that may seem great at the outset when you look at that. Hey, great, I get money out of my company. But remember, it's your company. You control it. Why do you have to have an operating agreement tell you what you need to do? Why not allow the operating agreement to give you discretionary authority to make those distributions? Here's why it's important. Let's assume that you're sued and they get a judgment against you and they file a charging order on your limited liability company. And you know all about charging orders by now if you've been a member of my channel for a while, that you don't have to distribute any money out. The creditor doesn't get paid. But oh, wait a minute. Your operating agreement doesn't give you that discretion any longer because your operating agreement forces you to distribute money out of it. See what can happen? You could have a judgment entered against you, charging order entered against your LLC. You sit back and you say, well, this company's not making distributions. They pull up your operating agreement and say, see right here, it states you got to distribute out all the profits on an annual basis. So that is a trap. Do not have any language in there that forces you to make distributions, which brings me to my third point in this. You want to make sure that your operating agreement has what's called non-prorata distributions. All right, so that is another important clause that goes right along with that. And with non-prorata, what it means is that if there's multiple members in your LLC, you don't have to make distributions equally. let's say I created this limited liability company and I have another partner involved. And this partner here is going through a divorce. And so that partner doesn't want to take any money out right now because it's just going to complicate their divorce. So they want to keep the money inside of the company. Well, what does that do to me? So I need the money. I want to take the money out. Well, if it's pro rata distributions and we have $100,000 in here, then you would have to divide it up 50-50. 50-50 like that. So I would get 50K and my partner over here, she's going to get 50K, and then possibly that money is going to go into the attorneys and get spent and disappear. So if I have non-pro rata distributions, it allows me to take my money and I don't have to give it to my other partner. Think if you had kids involved, same scenario here, right? You could have a couple of children involved in your LLC at some point in the future. Just because they're there doesn't mean they get money. You decide who gets the money out of the entity, and it doesn't have to be equal. So you'd want to create your entity with non-pro rata, and you'll see that in the distribution clause. All right, the fourth issue is going to be no charging order language. Okay, this is important to have in your LLC to state that in the event a member is under duress, that your company, if a charging order is entered against you, that you do not have to distribute money to them, that they cannot take your interest from you, that if a court tries to award their interest, they become an assignee. Not having charging order language in your LLC agreement that addresses these issues can be a problem. If a lawsuit develops and a judgment's entered against you, you may lose your interest, or the person that is awarded your interest can assume control over your company. So you want to make sure that you're limiting that. Which brings me to my next point, 5. Restrictions on transfer. Okay, no restrictions on transfer is really what we should be writing here. You have to make sure that you have this type of language in there that you can restrict who can become a member in the LLC. So by putting restrictions in your operating agreement to restrict the transferability of your interest, it prohibits or makes it very difficult for a creditor to get your interest. But more importantly, if you're using your LLC in the future for estate planning reasons and you, again, bring other people in, you know who you're getting involved with. The worst situation you could possibly find yourself in is that individual that you're working with now transfers their interest to someone else. And now you're in business with someone you never knew. Who wants to be in that situation? But if you have restrictions on transferability to stop people from being able to just transfer their interest to anyone at any time, then you can be assured that the members will stay the same unless you agree to the transfer. So restrictions on transfer, really important. Number 6, okay, improper tax provisions. All right, improper tax. What does this mean? Well, an LLC is a hybrid entity. So in a hybrid entity, you can choose how you want that entity to be taxed. It can be taxed as a C Corp, S Corp, partnership, or disregarded entity. So many operating agreements are drafted as partnerships by default, but then the client chooses to set it up as a C Corp or an S Corp or maybe even a disregarded status. So it doesn't match the operating agreement. And so where you can get into problems is with the IRS, that you're paying taxes or you're treating your entity as a corporation, but it says it needs to be a partnership. So that could raise your taxes on you if you were audited. Or if you're involved in a lawsuit, someone could say, look, he has an LLC treated as a corporation, but it's an operating agreement conflicts and it's treated as a partnership. Maybe there's a benefit there for the creditors. So you want to make sure that the tax provisions inside of your company agreement match the tax election that has been made with your limited liability company. All right, number 7. Okay, right to return of capital. This is an issue. When you have a right to return of capital inside of there. What it means is this, that if I put in $100,000, then I'm entitled to get that money back. No, we don't want that, right? It sounds great, just kind of like the forced distributions. You have to distribute the money to everybody on an annual basis. But think about this for a minute. If I'm putting $100,000 into an LLC that I control, I can take it back at any time. Why do I want my operating agreement to state that I have a right to get that money back? Because what that could do to you in the future is that if you're involved in a lawsuit, judgment's entered against you, maybe a creditor now has found a way, maybe they can't take it all, but they get a piece of that company because they go back in, they grab your interest and they say, well, we're entitled to receive our capital back, distribute our capital back to us, and they take it back. So you want to ensure that your operating agreement states that there's no right to return of capital. You do not want to have a right to receive your money back. You have that control. You can decide if that's ever coming back. And the last issue that I see that I think is really important is no officer appointment provision. Okay, so when we talk about limited liability companies, we talk about member managed or manager managed LLCs. But guess what? You can also appoint officers. And here's the thing. I like having these provisions inside of my operating agreements to allow you to be a president, secretary, treasurer, so you can operate as an officer of that company. You don't have to adopt the label as manager when you're dealing with third parties or member when you're dealing with them. You just tell them you're a president. It gives you apparent authority, number one, so that you have this control. And when you start to build out an anonymity structure, like I've shown you in many of my videos, where you have a Wyoming LLC owning in-state LLCs, it can get kind of complicated for third parties to say, well, who's really in control here? Well, it's real simple now. If you have a provision in your operating agreement that allows you to appoint yourself as a president, appoint yourself as a president. And then you can say, I am in control of this company as its president. And here's the nice thing about it. When you have officer provisions inside of your LLC, you're allowed to appoint these individuals as officers. They don't get listed anywhere on the Secretary of State's website because that information isn't collected. So you can control it without anybody knowing you're in control of it if they look at the Secretary of State's website. So it gives you some de facto anonymity there. Having officer provisions gives flexibility. Make sure you have that in there. Here's 8 of them. There are so many more we could go through. I don't want to have the time, but these are the 8 key provisions, mistakes that I see in a lot of operating agreements that you should check yours for right now to ensure that you have the protection you're seeking. All right, guys, if you like the channel, give me a like on that. If there's any comments about that, put some comments down below, and I'll get to those relatively shortly to make sure you're getting your questions answered. Thanks.